The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Good morning, everyone. Please be seated. Welcome to a new world from the bench. As I look out and see everyone with masks, this is our first hearing of the fall term. And if things don't feel different to you, I can't imagine. Maybe it's because we've kind of gotten used to it. But from the perspective of the bench, I want everyone to know that we are complying with all of the regulations and rules that we ourselves have put in place for our entire judicial branch. Whether or not you can see it, each of us is separated by plexiglass. We're wearing masks at this time. Some of the judges might change their mask to be a shield during the hearing. But we will be practicing this continued social distancing throughout the term until we are told otherwise. We appreciate everyone sitting out there with your masks on and maintaining social distancing, and as well as the counsel. I think the rules are pretty clear in our orders, but just to make sure, since it's the first hearing, typically, the lawyers would argue at the center podium, and we are asking you to use your desk podiums today instead. And each of you will, the cameras will toggle back and forth as you're speaking. Justice Appel, can you say something?
Yes, good morning, everyone.
Thank you. That's Justice Appel participating remotely. And the camera will switch to his voice when he speaks. We intend to try and make this as user-friendly as possible. Bear with us. It's our first time doing this with this format, as well as I'm sure yours in the state of Iowa. So with that in mind, this morning we have 4 cases that are on the schedule. The first case is the case of Crystal Wagner versus the state of Iowa and William Speece. This is a certified question. The second case for oral argument is state of Iowa versus Stephen Struve. The third case is State of Iowa versus Fonte Bulow. And the final case is submitted without oral argument, State of Iowa versus Tavish Shackford. And that will be considered submitted at this time. So for our first case, Wagner versus State of Iowa, we have attorney David O'Brien and Jeffrey Thompson with the state. Thank you. You may proceed.
May I take my mask off while I'm arguing?
Yes, you may. Thank you.
May it please the court. My name is Dave O'Brien, and I am here today representing my client, Crystal Wagner, and I'd like you to meet her. She's standing right here. Her son, Shane Jensen, was shot and killed by a DNR agent of the state of Iowa on November 11th, 2017, and that's why we're here. She asked me to tell you that she appreciated that you delayed the oral argument on this case at her request. You need to understand that it's been 3 years since her son was shot and killed, and this proceeding here today is really the first time in that 3-year period that she has seen any evidence whatsoever that a government or agency or branch of the government has taken this seriously and is at least considering what happened to her son and whether the person who engaged in the wrongful acts will be held accountable. But I do think we have to keep in mind that we're not talking today about whether or not Mr. Speece and the state of Iowa will ultimately be held accountable for the wrongful conduct we've alleged in this case. We have a fight we have to go through to find out if we can have the fight that we want to have, which is to hold the state accountable for the wrongful conduct. And this case is an egregious factual scenario. Shane Jensen was 19 years old. He was troubled. The local police officers knew him. They were familiar with him. They had used him to buy cigarettes when he was underage in sting operations, and also to buy drugs at different times and alcohol. They understood him. But an agent of the state decided to show up at a time that Shane, who was an emotionally disturbed young man, was threatening to commit suicide. And the DNR agent showed up from out of town and pulled out a rifle from the trunk of his car. I want you to think about that for a second. A rifle is not a defensive weapon. A rifle is designed to shoot game at a long distance. Why on earth would anyone feel it was necessary to bring a rifle to a situation where a young man is threatening to commit suicide, even if he has a gun? A sidearm, yes. These officers on this site needed to protect themselves. We don't have any problem with that. I pled in our lawsuit, and I did this intentionally because I think it shows you everything you need to know about Ms. Wagner. She had a conversation with these officers before this horrific incident occurred, and
Counsel,
she said,
could you respond directly to the state's contention that we don't need to answer the certified question in this case because there is no private cause of action against this individual in an individual capacity?
I certainly will. I certainly will, Judge McDonald. And the answer is very simply, I don't believe that this court can or should reverse its findings in Godfrey and both Baldwin cases, which is essentially what they're asking you to do. I also believe that the claims they're making with regard to not addressing these questions are, of course, not the way Judge Williams sees this case. And anytime I can stand by the side and say, U.S. Federal Judge Williams agrees with me on this issue, I could just point to him and say, read his decision on this point, because he's right. And these are certified questions that should be answered by this court. The other reason that we shouldn't avoid answering these questions is because that the dismissals that the defendants are talking about are all without prejudice. So I definitely, when we get through this part of the process, will go back and amend my complaint, depending on the findings that you folks make in this decision, to include those claims. They're not dismissed with prejudice, they're dismissed without prejudice.
Mr. O'Brien, is, although right now the claims against Mr. Officer Speece in his official capacity and against the state have been dismissed without prejudice, they would logically come back in if we agreed with your viewpoint on how this action proceeds under Godfrey.
That's absolutely correct, Justice. That's absolutely correct. But it goes further than that. I think their whole argument misconstrues the difference between what an official capacity claim is in federal court and what it is in state court. Official capacity claims in federal court have very distinct meaning and limited meaning. In federal court, official capacity means that the state actor is being sued in name only. You see this all the time. Iqbal versus Ashcroft. Well, John Ashcroft, the Attorney General, didn't have anything particular to do with that case, but he's in name only. That's an official capacity claim in federal court. But in state court, the official capacity claims are more akin to acting within the scope of the agency, which is covered in federal court by the under color of state law element of any case under 42 U.S.C.
I happen to agree with
1983.
you on that point, Mr. O'Brien, but doesn't that also mean that no matter what we do today, you will have your federal constitutional claims under 42 U.S.C. 1983 going forward against Officer Speece in his individual capacity? Isn't that correct?
That is true. That is true. But the question before this court is, should the Iowa Constitution, that has even greater protections for people like Shane Jensen, should it be applied, and should the state be allowed to violate its own Constitution in taking the life of a citizen unnecessarily? And I think the answer to that question, and the answer to the first question that's certified, is that the state municipal tort claim does not apply to these types of cases. Now, we can have some discussions about, sorry, I see I don't have any water, and I understand why, but I'm gonna have to take a second. We can have some discussions about different statutory construction matters, whether a comma in Article 12 of the Constitution means it's an independent clause, or whether the legislature using different language to define claims in the State Tort Claims Act versus torts in the Municipal Tort Claim Act, whether those should apply. And I'd be happy to win this case on those statutory construction arguments. I'm happy to win any time, but I don't think it's the right way to go because I think you get off on the wrong tangent. You folks are the Supreme Court of the state of Iowa. We're talking about enforcing the supreme law of the state of Iowa. We are relying on you to do that, not the people across the street. I know that legislature is going to change in the next few weeks. It's going to be different after the first of the year.
Mr. O'Brien, but why isn't the remedy under the Iowa Tort Claims Act adequate?
Well, it's not adequate because it doesn't allow for punitive damages, which are so important in this case. Punitive damages deter wrongful conduct. You have to keep in mind that by law, agents of the state are indemnified for any compensatory damages that are awarded. So the only true negative impact you can have against a state agent who shows up and kills somebody is if you allow for punitive damages. But it goes even more important than that.
Isn't there sort of a contradiction there? I mean, the whole notion of something being remedial is that it fixes the wrong to the person that is in front of the court. Punitive damages go beyond that. They're intended to, as you say, deter wrongful conduct in other cases. Isn't that sort of more than remedial?
No, I think it's exactly what's required, Judge, and here's particularly why. You have to remember that in these types of cases, just because of human nature, the criminal sanction, excuse me, I've got a dry mouth, the potential criminal sanction against agents of the government and police officers goes by the wayside. It just doesn't happen. Now, in other parts of the country, we're starting to see some criminal cases being brought against law enforcement officers who violate people's civil rights, like Mr. George in Minnesota. But I can tell you from recent experiences that officers in Maquoketa sat on a guy's head, Drew Edwards, for 12 and a half minutes until he was dead, and there was no criminal charges filed against him. Those officers weren't even reprimanded. And if you want to know whether or not the city really thought that their officers did everything okay, there was a multi-million-dollar settlement that was reached that tells you everything you need to know about whether they believe their officers acted correctly or not. So the inertia of the system in the criminal justice system is to exonerate these police officers. Now, I'm not accusing anybody of corruption.
Hey,
I don't.
Counsel, in one of the Godfrey cases, we said the Iowa Civil Rights Act provided an adequate remedy, so we didn't need to imply a constitutional one when there are no punitive damages under that statute. Shouldn't that guide our decision today?
Well, Justice Waterman, I'm glad you raised that because I think the concurrence from Chief Justice Cady speaks volume and answers that question. He said in that case, there is an appropriate remedy and that punitive damages are not necessary. But he also said in a case, I mean, he foresaw this type of case coming before this court. He said in a case where there has been an infringement of physical security, privacy, and bodily integrity, punitive damages may be necessary in order to vindicate the right and to deter the kind of constitutional violation from happening again. And that is exactly what we have here today. I can't imagine.
Mr. O'Brien, what role do the other branches of government have in enforcing or regulating a Godfrey-type claim that we recognized? Is there any?
I don't believe so, Your Honor. I mean, I think the legislature could enact a piece of legislation like 42 U.S.C. 1983 to set out a forum or a process by which we could handle these claims.
Could the legislature set a statute of limitations on a Godfrey claim?
I think it could potentially set a reasonable statute of limitations, yes. And I think it could set a reasonable process by which these claims can be processed. But the Municipal Tort Claims Act nor the State Tort Claims Act are those processes. We should not have to follow, particularly in the State Tort Claims Act, those processes in order to vindicate these state constitutional rights.
And what specifically in the Iowa Tort Claims Act do you find inadequate if you concede that the legislature has some role in regulating these types of claims?
I think the role of the legislature is limited by what's fair and reasonable as found by this court. But to answer your question, the claims can be regulated, but there cannot be roadblocks put up that limit people from being able to assert these claims. So, for example, the notice requirement, I don't think should apply. I don't see why, to enforce a constitutional claim, we have to jump through extra hoops that we don't have to jump through in order to sue somebody that ran a stop sign and caused a motor vehicle collision.
What do you make, Counsel? I'm sorry. What do you make of Section 669.14.4 of the Iowa Tort Claims Act, which excludes assault and battery? Would your claim be excluded under that provision?
Well, potentially, if this court decides that the State Tort Claims Act applies and we're limited by those, you would be giving free rein to any state agent to commit assault and battery and shooting, including shooting and killing someone, and not have a remedy under the Tort Claims Act because of that provision. And again, the legislature could change. They could add a whole laundry list of additional exceptions to the Tort Claims Act, and I don't think that should be allowed.
Well, couldn't we apply sort of a severability approach? I mean, when the state adopted the Tort Claims Act, 50 years ago, the legislature well believed and understood, and everybody said at the time, this is the only way you can sue the state on tort-type claims. Otherwise, you're barred. And historically, you had been barred. Even in Godfrey, there were no examples given of cases pursued against the state or state officials for constitutional violations prior to the ITCA. So can't we apply sort of a severability approach and say, well, we'll apply the Tort Claims Act to constitutional claims procedurally, because those procedures don't prevent you from getting a day in court. But we won't apply provisions of the Tort Claims Act that prevent you and your client from getting a day in court. Can't we, give you half a loaf?
Half a loaf is certainly better than none. I haven't given that much thought. I think that's a very good question. I can't say that I would have a tremendous amount of objection to that kind of result, as long, if you're just saying that we have to let them know about the claim or whatever the basic requirements are, the statute of limitations. I mean, I'm not talking about crazies. I get that. But when you start strictly applying the State Torts Claims Act with all these exceptions, which can be changed by the legislature at any time. I mean, Article 10 says there's this very specific way to amend the Constitution, and it doesn't allow the legislature to do it anytime it feels like it. And if you give them that power, I think they will have that authority. I forgot to reserve time for rebuttal, but I'm happy to answer any questions that anyone may have.
Actually, you'll have 5 minutes at the end.
Oh, automatically. That's great. Thank you, Chief Justice.
Mr. Thompson.
Well, without question, this case arises from tragic circumstances. And the questions posed by Judge Williams are important questions that this court will have to answer someday, but not in this case. And the reason this case is inappropriate is because there are no valid, viable Iowa constitutional claims pending in the district court from which the certified questions request came. The reason for that is very simple, is the individual capacity claim pled by plaintiff in this case is not the claim that was recognized in Godfrey 2 and then dealt with in Baldwin 2, Baldwin 4, and the Vankis case. It is an individual capacity claim, and in each of those following cases after Godfrey 2, this court said that the claim recognized was a claim against the state of Iowa, and state officials acting in their official capacities could be directly sued under the Constitution.
Well, Mr. Thompson, as I look at the certified questions, that's not one of the certified questions. I mean, we can walk through them, A, B, C, and D. The court didn't certify that as a question before us. It seems to me we ought to answer the certified questions and not something that was not on the court's mind.
Well, I mean, but that's the point, Your Honor, with all due respect, is the standard for answering certified questions include that the answer can be determinative of the cause from which those questions arose. And in this case, it can't.
Originally pled in the case official capacity claims and claims against the state under the Iowa Constitution?
I believe there were, although as Justice Williams or Judge Williams said, it's kind of hard to tie it together, but those.
If, let's say, we agreed with Mr. O'Brien on everything he's arguing, wouldn't he have an argument to go back to Judge Williams and say, let's reinstate those claims?
He would, but then he's got a different problem, which is the 11th Amendment doesn't permit him to bring those claims in federal courts.
Well, that's one of the certified questions we didn't get to. That's the fourth one. If it's a question of state law, I have my doubts, but it seemed like that was the fourth question, maybe, is whether these claims can even be asserted in federal court if he gets through all the other obstacles. What's your view on that?
Well, I mean, the view on that is that's not a question of state law. I mean, that's absolutely federal law. And that's why Judge Williams already dismissed all the pleading claims that dealt with official capacity or the state of Iowa. There is no basis for him to assert this official capacity claim in federal court. What I think
You
is
say that, I mean, the state can waive its 11th Amendment immunity. Is whether the state has waived or not an issue of state law, potentially?
no, it's federal law, but we didn't, I mean, I don't think there's even an allegation that we waived 11th Amendment immunity in this case. This case was initiated in federal court. We were sued in federal court. We filed a motion to dismiss, asserting the well-established law that the state and official capacity claims can't be brought in. Judge Williams dismissed all those claims. So that's why all that is left.
But wait a minute, the 11th Amendment claim is basically, or the 11th Amendment issue is a federalism issue. If the state of Iowa permits direct claims under the Constitution, it seems to me there'd be no basis for asserting an 11th Amendment claim. I mean, you got to have a remedy for the direct constitutional claim. It seems to me the 11th Amendment argument is inconsistent with the notion that you have a direct constitutional claim.
Well, no, it's not, with all due respect, Your Honor. I mean, you've got a remedy to the extent you have it. It's in Iowa State Court. It's an Iowa-based claim. There's no basis for federal jurisdiction. And frankly, you understand from our brief, we believe that this official capacity claim that was recognized by this court repeatedly also would fit into the Iowa Tort Claims Act as a basis for the waiver of sovereign immunity that's lacking in this construct. And
let's talk.
You didn't remove this case, did you?
no.
So you don't have that waiver argument?
No, and so that's raised in the briefing, I think, as an argument that some days in other cases, the state has been known to remove cases to federal court, and I'll say that is true. But one of the exceptions to the 11th Amendment bar is consent or something you do in a specific case, but that's not a waiver for all purposes. And there are circumstances where we make a decision where somebody has pled into federal jurisdiction to remove cases to federal court. And when we do, we understand, we're cautious about it, that we are consenting to jurisdiction, and so we can't assert 11th Amendment.
Counsel, the Iowa Tort Claims Act bars punitive damage claims and also doesn't allow attorney's fee recovery, which the Iowa Civil Rights Act does. Does that make it different from the Civil Rights Act outcome in Godfrey, where at least a majority of the court said the statute was an adequate remedy, so you don't need to imply a constitutional claim? How do you?
I don't think it does. I mean, this court in the two most recent cases, in Baldwin 5 and Venkis, adopted the Municipal Tort Claims Act as a framework for these constitutional claims. In both cases, no punitive damages, no attorney's fees, and the court found that the self-executing cause of action needed to be brought there, in part because of the need for a waiver of sovereign immunity. And so I think this adequacy argument sometimes is a little bit off base, because the remedy that's created, you've created a cause of action, but the Iowa Tort Claims Act is remedial in the sense that it's a waiver of sovereign immunity. And although it's
Yes,
limited,
but counsel, the the whole notion of a direct constitutional claim can't be limited by notions of sovereign immunity. Otherwise, the legislature would have complete authority to say no sovereign immunity is waived, no direct constitutional claim. It seems to me the purpose of the Iowa Tort Claims Act is to provide a structure for waiver of sovereign immunity for what I'll call ordinary torts, and to hold the state liable to the same extent a private person would be held liable. That's ordinary garden variety tort claims. It's not a constitutional claim. No private party can be sued on Article 1, Section 8 theory. The purpose of the Iowa Tort Claims Act is to structure waiver of sovereign immunity, but sovereign immunity is completely inconsistent with the notion of a direct cause of action under the Iowa Constitution.
Well, with all due respect, I disagree, and here's why. I mean, I think, again, this court has said in a couple of its decisions, a tort is a tort. This is a constitutional tort, and it's a tort. But Justice Apple, you wrote a decision where you recommended and got enough votes to adopt what you characterized as a Bivens action, which is a constitutional federal tort claim. And
not subject to the, no, it's not, the Bivens claims aren't subject to the Federal Tort Claims Act.
That is true, but they are subject to sovereign immunity. And so if you go back and read Bivens and you read Justice Harlan's concurrence, which was the vote that was needed to get that done, he explained why the need to create this individual capacity claim existed in the federal system, and said that a direct action against the government was not possible because the sovereign remained immune. And if you look, frankly, at Chief Justice Berger's dissent, an extended discussion about why the exclusionary rule would not be sufficient under the circumstances, but he said, in light of sovereign immunity, that the remedy, the fix of this thing would be for Congress to pass a statutory scheme that waives sovereign immunity for these claims and created an administrative process where people can get redress. That is exactly what the Iowa legislature did back in 1965. I mean, if you look back to Godfrey 1, which is kind of the precursor to all this, and these cases flow from that, Justice Wiggins wrote a really good history of sovereign immunity in the state of Iowa, and he talks about the progression from absolute sovereign immunity. The court didn't like that, so they did create an individual capacity right to sue in Iowa. The court then backed away with that and focused on scope of employment and misfeasance and malfeasance and nonfeasance, which got complicated. That's what led the Iowa Supreme Court, the Iowa legislature, to create the Iowa Tort Claims Waiver, which struck a balance. It created a remedy.
Counsel, why did the legislature specifically refer to constitutional claims in the Municipal Tort Claims Act, but not in the Iowa, in the ITCA, and does that make a difference?
I don't think it makes a difference, and I think it's because, two things. It was drafted in a different way, but if you look at the definition of claim, the threshold definition of claim is so broad. Any wrongful act is as broad as you can possibly be. When we get to the specific discussion of constitutional claims, it is in the defense and indemnity provisions that deal with defending and indemnifying employees of the state, which is why one of the circular things that's going on here is if you had created one that looked like Bivens, but allowed the lawsuit to go against an individual employee in their individual capacity, number one, it would be unnecessary because Bivens solved a problem that the Iowa legislature had already solved, and because the Iowa Tort Claims Act contemplates defending and indemnifying employees sued for stuff in the scope of their employment, it would get swept up in the Tort Claims Act as well.
All right, so Mr. Thompson,
I
your
wanted to follow
position.
up on a question that Justice Apple had earlier, and it related to the provisions disallowing claims for assault, et cetera. So what remedy does a plaintiff have in not a case of homicide as this one, but an assault by a state officer?
Well, I think in the context of the Iowa Tort Claims Act, it's a limited waiver, and I think it excluded certain things. And I think that assault like I think this would be the functional equivalent of assault. I think the
So-
statutory framework excludes it.
Here's my question then. When the Iowa Constitution was adopted, it was adopted with a certain set of, I guess, assumptions. And in this case, the assumption would be that the conduct of government officials would still be regulated by common law torts, because there was no concept of state action.
Right.
So if I take your argument to its limit, it's essentially without, that this conduct is wholly unregulated by state law, essentially, in the case of assault, false imprisonment, et
I
cetera.
mean, in the narrowest sense, I mean, I think, yes. I think that Justice Mansfield had a conversation with counsel about severance. So, I mean, in a focused issue on a specific issue, I mean, this court can look at the constitutional provision and the statutory provisions and talk about severance. But I also think, again, the remedy
But
here.
doesn't that, I mean, I guess the gist of it for me and my concern is
Right.
that seems wholly inconsistent with kind of the regulatory framework as it was established at the time of the founding, which is that private citizens would have some sort of cause of action against government officials, and we didn't recognize constitutional torts then, but we had common law claims.
Well, okay.
And now we have nothing.
I understand your, I don't think that's true in the sense if, again, if you go back to whether it's Justice Wiggins' history of sovereign immunity in Iowa or some of this stuff in our brief, frankly, is if you go all the way back to the founding, to the constitutional provisions, I mean, sovereign immunity was absolute, essentially. And that what would happen is, you know, as a practical matter, that official capacity would be asserted in a defense against an assault allegation, and then that would be a government official's ability to assert sovereign immunity. I mean, I think that, as I said, I think
Isn't it important to distinguish municipal officials and state officials? I mean, the examples given in Godfrey of successful common law or constitutional claims involve municipal officials. I'm not aware of any against the state or a state official prior to 1965 that was pursued. Certainly, there's not an example that we've given in our recent case laws. And
Right, that's true, and that's what I was about to say, that in the history that I was talking about, it was 1938 that the Iowa Supreme Court talked about this idea of an individual capacity claim to try and, you know, deal with the conundrum of sovereign immunity. It led ultimately to the Iowa Tort Claims Act. But I mean, the idea that at the very beginning, there was an idea that peace officers could be sued for damages, at common law, that was never true. It was an exception.
You know,
later.
at common law, that was true. The sovereign was the sovereign. You could pursue a private cause of action against an individual, and it was up to the sovereign to choose to indemnify.
Well, yeah.
Right. That's a totally separate thing.
Yeah,
I mean, you still
I
have a
guess-
claim against an individual, and the sovereign can choose to indemnify or not. But that's a decision, and those are totally separate things in my view.
Well, again, I think I just said under the Iowa Tort Claims Act, if you decide it was an individual capacity claim, so now we're talking individual versus the state, the Tort Claims Act requires the state to defend and indemnify with certain limitations. In other words, if you look at that statutory scheme, you sue somebody in the individual capacity, you've got a couple of things. You've got scope of employment you have to deal with, which is very broad. But after that, we have a duty to defend and indemnify, provided we get cooperation and then with a right of restitution for willful and wanton conduct. So
Mr. Thompson, you can wrap up.
I am done, aren't I? I can't find the numbers here. If there's any other questions, I'll be happy to answer.
By the way, you guys can stay where you are. We've heard that the mics have been fixed, so we'll see if they are, Mr. O'Brien. Did you want to wrap up, or you?
I think I'm fine, only to say that really two things. One is that this is the wrong case to answer these important questions. We've talked about a lot of substance here. It's not really pertinent or determinative of this case. We've developed so much of this law in a broken way through a series of interlocutory appeals and certified questions that, like in this case, jump over issues that need to be resolved and start answering questions before the predicate is solved. And so we would urge you not to answer these questions, and if you do, apply the Tort Claims Act. Thank you.
Thank you. And we'll do a sound check quick if you don't mind, Mr. O'Brien.
First of all, there is absolutely no reason to apologize for some of the problems that we're going through. These are inevitable. We appreciate the court allowing this oral argument. We understand that we have to take these kinds of precautions, and we're just very, very happy and proud to be here presenting these arguments.
I'm glad we're having this opportunity too, because I'm learning a lot as well. I would like you to answer, Mr. O'Brien. Under the 11th Amendment, doesn't that bar you from bringing your Iowa constitutional claims in federal court, even if you can bring the identical claims in Iowa state court? Isn't it a forum sovereign immunity provision? Isn't that a problem?
Well, I don't think so, for the reasons that Justice Apple stated, that there is a waiver. I didn't think of this in our brief, but it occurred to me, as suggested by Justice Apple, that there is a waiver by allowing these kinds of claims to proceed under Godfrey and under Baldwin. That's number one. Number two is, I don't think jurisdiction of the federal courts is dependent on what side of the bed Mr. Thompson gets up on any given day. I mean, they either have jurisdiction on these kinds of cases or they don't.
I know, but that's a kind of a common thing defendants do. They remove cases when they want to, and they don't remove them when they don't. And the U.S. Supreme Court has said if you remove it, you waive the 11th Amendment, which only seems fair since you're the one that pulled it into federal court. But here you filed it in federal court, and as I read precedents around the country, even direct constitutional claims, even Godfrey-type claims, they're barred under the 11th Amendment unless the state in that particular case has waived its 11th Amendment immunity in federal court. Isn't that a problem?
I think it is a problem, but the solution to it, I think, is even worse. And that's what you're presented with, because if you proceed to find that because they have refused to waive sovereign immunity in this case, that we can't bring state constitutional claims in federal court, we're going to end up with two causes of action over the same set of facts, one pending in federal court, one pending in state court. Because I can tell you, and I hope you would agree with me, that the federal courts are not going to look kindly on Iowa saying you have to bring federal constitutional claims in Iowa courts if you want to add and include state constitutional claims.
I agree, but isn't that a consequence of the 11th Amendment? I mean, I agree that's practically not a great solution.
Yeah, it might be. The way it's interpreted, of course, the 11th Amendment by its very language doesn't even apply in this case.
I recognize that, but since Hans and, whatever it was 100 years ago, it's been interpreted to apply to citizens of the same state. Isn't that right?
Those darn activist judges expanding language.
Way back in the 19th century.
Yeah. Who knew? But yes, I understand that that's a problem, but I do believe, as I said, that the solution is worse than the problem. And I'm guessing that the defendants would probably agree to waive rather than have two separate trials and two separate litigations going on, depending on what your ruling is. And I also believe that you have an inherent power in this situation to say we're going to allow it. Now, that may be a bit of a stretch, but I do believe you have that authority. You ultimately decide.
Counsel, sorry.
I'm sorry.
Where would we get that power?
From the Constitution itself. It says you're the Supreme Court of the state of Iowa, and the Constitution is the supreme law of the state of Iowa. I think you have the authority to interpret. I don't think you not only have the authority, I think you have the obligation to interpret and enforce the Iowa Constitution in ways that you see fit and justified. The only other thing I wanted to say was about punitive damages and how important they are in this particular case. It is important for the deterrence. It is important because it allows the defendant who has committed the wrongful conduct to have to pay a certain level of damages out of his or her own pocket for the consequences of their wrongful conduct. And it is so important that we have that deterrent, particularly in light of these cases where the criminal sanction is often not available because of reasons that I already talked about. And I don't see why we should, at this stage of the proceeding, say, never, under any factual circumstances, are we going to allow punitive damages. I mean, if I get a jury to go crazy and award a bunch of punitive damages, this court may not get a chance to review it, but certainly Judge Williams will, and the Eighth Circuit, and believe me, I don't want to be there on a punitive damage case. So you can always come back in later and further delineate these rights. So why, I don't see any particular reason why you would say now, never, we're not going to allow them. And we ask you not to answer the question in that way so that we can proceed with this case and we can get to the merits of the matter. With that, if you have any other questions, I'd be happy to try to answer them. Thank you so much for your time.
Thank you, Mr. O'Brien. Thank you, both parties, for your patience, and this matter has been submitted. We will take a brief break. I don't think we're going to leave the bench, but we want to do a sound check before our next case. Thank you.